well, I think what I'll do is I'll just get started by just saying to everyone, welcome so much, good afternoon. Thank you for tuning into this webinar. We're talking about some exciting stuff today, the New Zealand law updates that are going to be happening this year. Some of them are coming into place quite quickly, and then we've got some that are in the foreseeable future. Just to give you a bit of background about me, my name is Sanam. I work as Employment Counsel here at Employment Hero, and in terms of my background and my experience, I have been working in the private practice sector as well as in-house. During the thick of COVID, I've worked for hospitality businesses, and my experience extends to basically employment relations as well as employment law. So I definitely understand the pain points that employers feel, and I hope that today we can tackle some of these areas in the webinar. We've also allocated, as you will see, this is a live Q&A, so we've allocated some time to answer questions. So if you have any questions, feel free to leave them down below in that chat function and the Q&A function. If you have any specific issues or anything like that, any tech problems, please feel free to pop those in there too. Also, with today's session, it will be recorded. So don't worry about having to frantically write everything down. We will definitely have it recorded and send everybody a link or access to the recording. Now that we are officially getting underway, I'll just talk a little bit about what our agenda will look like today without having to go through the entire thing. Today we'll talk about a few things, like I said, things that are actually updates that are coming into place quite soon. So things like the minimum wage, all the way through to what we are seeing potentially coming in, like modern slavery legislation, or even looking at the amendment to the Employment Relations Act. Before we fully get stuck into it, I did want to do a little quick disclaimer. Please know that this information that we're providing you, it is general information. If you are dealing with a personal situation with a particular employee or employer, please seek legal advice from somebody in your area. Definitely, if you have any specific legal questions, it is best to seek legal advice. But for now, this is provided to you in good faith, just as some general information to get you started. Now, the employment law updates for this year in New Zealand. The first thing that we have up is the minimum wage. Now, as you know, being employers, many of you would be dealing with the minimum wage rising each year, and after much deliberation on the 1st of April this year, the minimum wage will rise again in New Zealand to $22.70 for the adult minimum wage, and then we're also looking at $16.69 previously for this training and starting out wage, now moving in to $18.16. If many of you have engaged training or starting out workers, then you'll know that this is a particular category usually associated with employees that are either undertaking a course, and it has to be a registered course through an institution, or they are of a certain age, like 16 or 17, and very new to the workforce. So I would say that this is a time as more of a reminder for employers to have a look at who's sitting at that minimum wage level, and see if they need to be moved on to the new minimum wage, and also to kind of reassess anything that you have internally and notify your staff as well of that. So that's the first major change that we're seeing coming up for the year. Another thing that has actually already happened is to do with migrant workers. Now, with migrant workers, many of you, if you have engaged people on visas, then you would know that in 2021, there was all this discussion around accreditation, employer accreditation. There were many questions around what this actually is and what it means. Now we've got a lot more clarity around it. The essential skills visa that used to exist, if you did employ people on visas during COVID, has moved to now being something called the Accredited Employer Work Visa. And what has happened with this particular visa is now the base rate of wage has actually been increased to $29.66. However, this rate has not been increased across all sectors and industries. So if you are in a particular industry or sector dealing with tourism, for example, hospitality, we're looking at maybe meat processing, seafood processing industries, seasonal work, things like that, then you wouldn't, at this stage, you wouldn't actually have to look at that change to $29.66. Right now, it's 25. It's moving to $28.18 in April, and then it will go to $29.66 next year, April. So the reason for this, accreditation program, I know a lot of employers had questions around this, and the reason for that was because there has been a huge push, and we saw this during the Essential Skills Visa, to do the labour market tests for employers to actually try to test, the area around them and see if there is anyone local that will, want to engage in that work and take up that job. And again, that's the whole point of the accreditation, is to do a similar situation where you're upskilling, training local, New Zealanders, and then you look at migrant workers as a second option. But I understand the difficulty around doing that, and also that there is quite a skills shortage, and like I said, being in the hospitality industry in the thick of COVID, I absolutely saw that, and even now. So with the change that's happening, I would say keep an eye out if you're employing people on visas. The accreditation program or the Accredited Employer Work Visa can be quite beneficial, just so that all of your policies and your documents are up to date, because there is quite a lot required for that process. But keep an eye out and just keep monitoring any of these changes as well, just so that you meet the immigration requirements. So we'll move on to the next part, which is fair pay agreements. Now, this, I'm sure all employers feel like this has been done to death. We've got, fair pay agreements that have come into place last year in December, and now we're looking at the, not necessarily the aftermath, that sounds very, very looming, but more so about where this is shifted now that fair pay agreements have come into place. So we do have 3 at the moment of applications sitting with MBIE, and MBIE will have to go through each one, dealing with the hospitality industry. There's another one for interurban, rural urban transport, and then you also have one for supermarket and groceries. So that's going through the process. It'll be interesting to see where this lands and what this means. We see Australia having a very similar system with the modern awards, and it will be interesting to see with these industries where this is headed. But like I said, at the moment, it's at a reviewing stage. It's being assessed by MBIE, and we'll definitely, I'm sure we'll hear more as it progresses. But for now, we're just sitting tight and seeing what's going to happen. Just a reminder, keep in mind that these fair pay agreements were there so that they create fair bargaining between both parties and a fair bargaining process that's compliant. So that was the whole push to introduce these in, and they, depending on the industry and the sector, that's how they'll slowly be introduced and reviewed. So we'll move on now to the changes that are coming up with the Holidays Act. So many employers, I know that it is difficult navigating the Holidays Act. It is complicated. It is a tricky piece of legislation. And one of the definite issues that have come up is how complicated it is. So a committee was formed in 2021, which was the task force to have a look at how can we make changes to the Holidays Act that will actually revamp it and allow it to be a little bit more user-friendly. So what's happened now is that this task force has gotten together. They've put together, some proposals around changes to different parts of this piece of legislation, and these have been provisionally accepted by government. So what we're looking at now is this potentially moving into a bill stage. So we're waiting for it to be drafted. And I'll discuss some of the changes that are actually going to come up from this, because like I said, we have a lot of things that we'll discuss today that might not necessarily seem like, you know, there's a hard deadline for it or a date for it to kick into force. But what I can say is that these are things that you should keep an eye out for, because they are going to be changes that will significantly impact the running of your business as an employer, and also you as an employee if you're watching from an employee perspective. So some of the changes that will come up will be around calculating leave. So we know that we have previous ways of calculating leave with the ordinary weekly pay, you know, and then we're looking at relevant daily pay and all of that. But that will now shift, and there will be a new way to do this, and it will be called ordinary leave pay calculations. So that's how that will come in. Then there'll also be changes to otherwise working day. Now I know the difficulty there is with trying to pay your employees for these public holidays that have been Mondayized and Tuesdayized, and you're sitting there and trying to figure out, okay, this employee has worked, you know, 3 Mondays in a row in the last few weeks, but then before that, they only ever worked on a Tuesday. So what is their otherwise working day? And hopefully with this new piece of legislation or the new bill that is drafted, there will be a clearer definition around what otherwise working day is, so that employers are able to also get the transparency that they need and the clarification. A big change that has been proposed and, you know, now accepted, which will come out in this bill, will be around sick leave, bereavement leave, and family violence leave. What we're looking at there is that for sick leave, the eligibility test will be changed to potentially an employee accruing their sick leave from day one, rather than that 6-month threshold and then the sick leave coming into place. The other leaves that are offered, bereavement leave and family violence leave, that has been proposed to start from day one of employment. So you can see that there's some big changes that are going to happen here. These changes are going to impact employers significantly, and I would say keep an eye out, because it even extends as far as pay as you go, and how the 8% is going to be considered as well. So with these changes, I would say it is difficult, and it is definitely trying for an employer to have to navigate this. But what I can say is that, you know, with the changes that will be implemented, there is a higher chance of transparency for the employer and the employee. It may alleviate a lot of the tensions or the difficulties that can arise in the workplace where there is uncertainty. But we'll obviously need to test these out and see how these go in you know, the employer and employee space. And see what happens with that piece of legislation. But like I said, nothing has been drafted yet. We're still waiting even for a bill to be drafted and put together, but we do know what you know, proposals have been pitched forward, and that this will most likely go ahead. So definitely stay tuned for that. All right, something that hasn't actually been spoken about very much in the employment space, you know, when it comes to MB putting out information, is around modern slavery legislation. Now, a lot of times, and the reason why I say it's not spoken about too much in the employment space is because a lot of it is usually focused on corporate and commercial law, or focusing on businesses and how they're running their systems. But when we look at it from an employment perspective, it actually goes a lot deeper. So with modern slavery, it is definitely an issue that is quite prevalent. And we can see it across other countries like Australia and the UK, who have already tackled it and put legislation in place. But with modern slavery, it can be the extreme meaning, which is you know, human trafficking, forced marriage, but it can also mean you know, worker exploitation, or looking at exploiting a person, like an employee, making them work excessive hours, forcing them into labor, things like that. So it definitely can very much interrelate and intermingle with employment law, and it is really important for employers to keep an eye out for this, because this is also upcoming. And the reason why it's coming up is because on average we are spending about $34 a week on products that could be linked to modern slavery. And the whole idea behind this is to have businesses become more aware and conscious of their practices, as well as to stop engaging in such conduct, or knowing that their suppliers or particular contractors might be engaging in this modern slavery or in worker exploitation. So just to give you a bit of an understanding about what's been proposed, at this stage, we've only received submissions and feedback about the idea of introducing this piece of legislation. So we, like it says up there on the screen, it's 5,614 submissions that have been received in favor of the legislative change. And what the change would mean for all organizations, so this is the base minimum across the board, that would mean that employers have this obligation to take action if they become aware of modern slavery or worker exploitation in the workplace. The next step up from that would be for medium to large companies only, where they would be required to disclose the steps that they've taken. So we can see with the smaller companies, you've got this understanding of, okay, have you actually engaged in this kind of conduct? Is this company engaging in this conduct? And we need to take action to fix this. But with medium and large companies, they need to disclose, what the steps are that they're actually taking. And with large organizations, they will also need to take the extra step of making sure that they undertake due diligence. So they cross every T, dot every I to make sure that this isn't happening in the future, and that they're putting a stop to it, and they're putting in processes and systems in place to prevent that from happening. But at the moment, we only have submissions that have gone to Parliament, and we are looking at now moving in the direction of a bill or proposing some sort of legislation, but it isn't there at this stage. So that's just a little bit of information around the modern slavery piece. Like I said, keep an eye out. We are waiting to see where this goes, but there are other areas it seems that the government is focusing on, and I'll discuss that in the next slide. The income insurance scheme is something that we discussed as well in our webinars last year. It did cause a lot of, and rightly so, a lot of concern amongst employers. Because of the fact that it was a program similar to ACC, where a levy was paid. We were looking at 1.39% coming from the employer and another set coming from the employee, to allow for 80% of wages and salary to be paid if an employee's role was disestablished, or they were made redundant. Now, since discussing this last year and tracking the progress on this, on the 8th of February, the Prime Minister actually announced that the scheme was off the table for now, and it will be for the foreseeable future. There is actually a number of programs that the Prime Minister has suggested to be cancelled, or they need to be delayed, because right now the focus, as it has come from government, is the focus is shifted to the cost of living issue. So that's where it seems that everything is headed. So like I said, with these things that are going to be coming out slowly, there is question around how much emphasis will be placed on them for immediate change right now, and to drive the process to get the piece of legislation up and running. So that's why I say just keep an eye out for the updates and see what else is around the corner. So as we progress through, one of the other aspects that came up last year, just like fair pay agreements, that was quite a big topic, was independent contractors and their clarification. So in October 2022, after much anticipation, we finally received a judgment around the Uber case. And this was a case where 4 Uber drivers said that, no, we're employees, we're not independent contractors. And after having a similar case go up a few years ago in New Zealand, this case definitely stood apart because it completely it changed the whole perspective about independent contractors in terms of now the definition of an employee, the meaning of an employee, as well as the employment relationships formation, that the definitions around that have been broadened. And what I could say for this particular case is that even though we've seen the case, we've seen the judgment, and now it's a matter of, okay, let's have a look at what's coming up in 2023, or if there's any cases that will test this. I would say it's a reminder for employers, and it is definitely a reminder that employers need to make sure that they are treading carefully in this space. So if you are dealing with any specific issues around independent contractors or employees, or you feel like after, I discussed this slide, that maybe it's leaning more towards an employee rather than an independent contractor, I would highly recommend you reach out and get advice from an expert in your local area, a lawyer or an advocate, because it is better to be safe in these situations. And what we saw from the Uber case was that the employees, or the drivers, they were not in business for themselves. They had no ability to set their own rates. They could not market themselves outside of Uber in terms of having their own business and marketing that. They were not able to contact their customers that would come through. If any of you have had to leave your phone behind or anything like that in an Uber by mistake, then you would know that it's a bit hard to contact the driver. You have to kind of go through Uber to do that. So all of that added an extra layer of control over these employees, and with that extra added level of and layer of control, that separates an independent contractor and an employee. So it was also added that the only way that these particular drivers could increase their earnings was not necessarily by marketing differently or anything like that. It would just be doing longer hours, and that would be very, very similar to what an employee would do. If you need to make some more money, you see if there's extra shifts and you pick those up and you do that. So you can see here that where the lines start blurring, that's where these drivers become employees rather than independent contractors. And I would say that when you remove flexibility, when you remove choice, and you start, including more control, then that's where this shifts more towards an employee situation. One part out of the case that was quite interesting was that I remember from my time in advisory, there are always reasons, I understand, for why an employer might need to integrate an independent contractor into the business. But I would always say, take it as a warning from the Uber case that you really need to consider, why you're putting a person, a driver or an employee or an independent contractor in that particular position. So in the Uber case, the reason behind why there was so much control over those particular drivers, let's say if the argument was for safety, it's much safer for the customer to contact Uber than to contact the driver directly. All of that was disregarded. It was considered as irrelevant. So what I was coming back to my original point is that it is really important for employers as well as people that are engaging contractors to have a look at exactly what are the reasons for why they might be integrating them so much or having so much control over them, because that shouldn't be the case. And what I would say is that as a reminder, this is a reminder that there's a 4-part test that's usually implemented when looking at these cases. We're looking at the first one being about how much, what the intentions were behind the parties. So was there an intention to actually engage them as an independent contractor? Let's unpack it. Maybe they were an employee and they've moved into this role. What's the ideas behind it? And then also looking at how much control is over them. I know I've driven that point in quite a lot, but it is really important. And integration. Generally, with an independent contractor, you wouldn't really have them quite heavily involved in your business. They wouldn't be coming to staff functions. I know that that's sad to say, but that they are considered as you would have your mechanic. You literally take your car in, or if you've got a painter that comes to your house, they come in, they do their work. You're not monitoring them. Well, hopefully you're not watching every brush stroke, but usually you would have the person come in, do the work, and then they leave and they bill for their services. So that's the approach that needs to be taken. And then you also look at who's actually benefiting and whose interest is the work for, and the economic reality of that. So I would say to employers, have a think about that. And like I said, if you're dealing with something like that in the workplace, really consider it. It's better to nip it in the bud now than to let it kind of progress, because these situations can become bigger, and it can be that the employer has to pay for not only all of the fees and everything that they've been paying to this independent contractor, but also back pay for employment entitlements and wages and all of that as well, and holiday pay. So definitely something to consider. Now, one of the last updates that is coming up is an amendment to the Employment Relations Act around extending time for personal grievance claims when they relate to sexual harassment. Now, if many of you have dealt with a personal grievance in the past before, or if any of you have been exposed to it, you know that generally there's 90 days to raise your personal grievance claim from the date when the employee has become aggrieved, or some situations happen. Sometimes it's their resignation or termination. But with this new extension of time, if the reason for the employee's claim is sexual harassment related, then that's where that 90-day period will extend to 12 months. So the employee wouldn't be considered out of time. But this is still a bill, and it is coming up to its third reading in Parliament. So most likely we're looking at it being implemented, but you just never know. So definitely keep an eye out for that. And that's definitely something that will be coming up as things progress. Now, I've spoken a lot about updates and what the whole purpose behind these updates are, and what the government has pitched forward. But I would say it's really important to consider why it's important to stay on top of these updates as well. It's a complicated area. Employment law is forever changing. It's complex, and it can make things a lot difficult when you're having to navigate your employees, as well as trying to figure out if you're doing right by them. I've yet to meet an employer that is trying to do wrong by an employee. Usually employers are trying to tread water, and they're really trying to just make it a place where people will want to work, and it is hard to stay up to date with things. So I would say that it's important to stay on top of these rules and find out where you can, anything that's impacting on your business. And it's important to seek legal advice from a professional if you are dealing with anything personally with an employer or an employee. But more so, if you are looking at staying compliant, then it's something where I'm really proud to say that Employment Hero is a company that can definitely help with this. I wish that I had known about Employment Hero when I was working in advisory, because there would be so many clients that I would have given this a suggestion to, because the amount of personal grievances and things that crop up just from compliance issues is a crazy high number. And in terms of the compliance piece, what we can do is offer automated payroll, digital contracts, just things to make life easier, to house them in one place. The last thing you want is to send out an employment agreement, a few years later an employee have an issue with it or something come up, and then you're digging through your emails to try to find where you sent it. It's great for it to be housed in one place. It's great for you to be able to get contracts and policies and that information as well. So it's something to think about. We have a HR and payroll system, and any of the updates that we discussed today, those are the kinds of things that we generally will pop in just to say that, look, hey, that this is something that's coming up, and we also put it in our social media as well. So now that we've reached kind of the end, I'll have a look at doing the Q&A component. I've had a few questions that have come in, so I'll just have a look through. So I've got questions around the living wage. So when the living wage will be announced for 2023, I will have a look into it and see if we can come up with an exact date, or if there has been any mentioning around the specific living wage. But at this stage, I don't know if there's been an exact a date that's come up, but we'll definitely have a look into it. And what we can do is we can always send something out to everyone. I've also seen a question around conditions around redundancy. So I think that this might be specific to a particular situation. So I would say definitely it might be more so to seek some advice around that, and find out from somebody locally if that is something that they can help you with. It seems, so if we have existing staff on a work visa, do their wages increase? From the accreditation visa, it will be that their wage will increase. However, I would say that it is really important to just reach out to Immigration New Zealand, just give them a call. Sometimes going through CAB, through Citizens Advice Bureau, is a little bit easier to tap into Immigration New Zealand. So I would say definitely worthwhile to chat with them. So now if we're looking at, so with, I can see one question about liability for public holiday pay for a worker receiving ACC. This would be something, it depends on a situation. ACC is a very contentious area, but essentially if an employee would have an otherwise working day be that particular public holiday, then you might need to pay them. But this is something that you'll need to discuss with ACC as well, to see how much they're paying this employee, and it can depend on if the incident happened at work or it didn't. So I would say definitely contact ACC around it, but generally an employee would need to be paid for their public holiday day under the holidays legislation. I've just got a question around modern slavery. Sorry, just bear with me. So the classification, I believe, is around potentially the turnover of the business, and there is a lot more clarity that will come around that. But I do believe that I did see some things that mentioned staff numbers as well. So I believe that there will be more information coming around about exactly how they set those parameters, but generally I would say that it would be turnover that they would be looking at. So again, I can see another question around the definitions around small, medium, and large. What I'll do is I'll see if I can put together some information that can be sent out just around exactly what the definitions would be, or how they would look at at differentiating between the three. All right, so I'm just looking at another. So I can see that somebody's just put in a question or a comment around changes to sick leave, and Employment Hero putting out an update. Absolutely, we will be sending this information out. Keep an eye out on our social media and other platforms as well. So another question has come up about the change for the personal grievances from 90 days to 12 months. And the question is around what happens if the person whose complaint is okay. So if the employee has left I think more will come out around the parameters, but it will be similar to a situation where if an employee resigns, then they still have the 90 days to raise a constructive dismissal, a claim or a personal grievance claim. So I still believe that there might be an opportunity for that employee to raise the claim, but obviously the specific facts and the scenarios will matter depending on if the claim is valid or not. I can see a question here about the comprehensive list of industries that are subject to different median wages. I can speak to our team about it, but I do believe that in the slides that we'll provide, there is a list, and I've also put in a link to the ministry's website where it will actually break down exactly which businesses and which sectors don't need to move into that category. I would also say highly recommend again. I know that calling Immigration New Zealand can be difficult and it can be long wait times, but I would definitely recommend speaking to them as well. And I haven't, another question that's come up and quite a valid question too is around what the assessment times are like for the fair pay agreements. We haven't really heard exactly how long this will take, from MB's perspective, and we also don't know if they're under the pump or anything like that. I'll have a look at seeing if there is any timeframes that they need to be working by, and then and to see if there's been any undue delay, and I can definitely come back on that one as well. Will there be more transparency is another question that's come up on accrued leave, as this is complicated, not showing. So I mean, I think that this question is more around pay slips and what will be coming up there. I believe that there will be more transparency around accruing leave and how that will work with the new changes to the holidays legislation. There will also be, like I said, a clear definition of when things are accrued, when it's going to be paid at 8%. So we will definitely see that, but it's just a matter of getting something down in bill format. But if you want, there are links to and I would suggest to go and look at MBI's website to get some more information about what changes they've proposed. There is a high level amount of information in there, but there's also a booklet that breaks it all down as well. I've got one question here, and this is quite a specific question, but what I'll do is I'll answer it. And I do suggest having a look into this a bit further, is around independent contractors and how they're being classed. So the question is that if an independent contractor is classed as an employee, how far back do you have to pay the new entitlement to annual leave? Look, there isn't any hard or fast rule around this. It depends on the situation that's come up. If you've got an employee that an independent contractor that's saying that they're an employee and you've engaged them for several years, then the safer option might be for you to actually pay them from the earlier days of their engagement up until that point. But like I said, each situation and each circumstance is so different. So you might have an arrangement where you don't go that far back, or you might choose not to. It's really important that if you're dealing with something like that, that you really go out and seek legal advice, and definitely go and speak to a lawyer about it, because like I said, that area is very tricky and it can be complicated and it can be quite costly as well. So I can see something else that's come in. If you just bear with me, I'll just have a quick read. So I can see something in here about somebody asking about looking at international workers or people that are migrant workers to complement their workforce, and they're asking around the minimum wage there. I would say that the way that it would work, and normally you would need to speak to Immigration New Zealand, obviously, to start the process and to get accredited and go down that path. I would say when you do speak with them, they will tell you exactly what the conditions of the visa will be, and that will be to pay at a certain wage rate. So that minimum requirement of the wage rate for the $29, sorry, and 66 cents, I believe it was, that will be the baseline. But like I said, speak to Immigration New Zealand. They're more equipped to tell you exactly what's required under the conditions of the visa. And I also can see another question that's come in that says, do you think that there are any crossovers with independent contractors, employees, and regular volunteers? Volunteers are always a very tricky area, to be honest, because of the fact that we don't really have the same kind of a volunteering or internship view as some other jurisdictions or other countries. With the independent contractor and employee space, I think that would be quite separate to a volunteer. Where it could cross over as a volunteer could start seeming like an employee. So we had the Gloria Vale case, infamous Gloria Vale come out last year. And when Gloria Vale's judgment did come out, what we saw there was that people that were considered volunteers, they could have been, they were employees of Gloria Vale and they're separate entities. So I would say that there is some crossover that can happen. And for volunteers, what you're looking at is, are they doing it for benefit? Who's the benefit for? Is it the company? Whose interest is this for? So those are all the aspects that you'd be looking at. So I think that there are some crossovers, but more so you can see a crossover between independent contractors, employees, or employees and volunteers. Another question that has come up is around accreditation. So I believe that the accreditation is only specific to the accredited employer work visa. But again, this would be something that you should check in just with Immigration New Zealand, just to make sure and see if that is, if there are any other requirements. But from what I understand, it is just for that particular visa. There is a question that's come in around, do I need to be accredited if I'm going to be if I have people on work visas or particular visas? It is really important to make sure that, each visa is different, and making sure that you've applied for the right one, and that's the one that that you're okay with applying for as well, it is considered. So I would say that definitely it's more so about making sure that if you're going to be accredited, that you're applying for the accredited employer work visa, and not necessarily that every visa will come under an accreditation requirement. I understand one of the questions that has come up is around clarification or clarity around excess hours when there's a skill shortage. I think that there is a stark difference between doing forced labor, excessive hours where people are not remunerated correctly. So you're paying below minimum wage requirements. You're not providing any rest and meal breaks. I absolutely understand that there is a skill shortage. Like I said, I've worked for the hospitality sector for quite some time, advising clients about the difficulties that they're facing and how to navigate that. And I would say that absolutely, skill shortage exists, but we're looking at worker exploitation where, an employee is coming in to do one shift and then they end up having to sleep on premises and then move into another shift, or they're being paid below minimum standards, or they're not given any rest and meal breaks and they're working 7 days a week, really, really excessive hours. And in New Zealand, there is no requirement in terms of giving, time off or anything like that, or having a day off, here and there, or working a set amount of hours, but there is a requirement for your rest and meal breaks. So if you have shift workers, then just make sure that those are all implemented. We don't know exactly when these holidays, Holiday Act changes will come into place. That is one of the questions that's popped up as well. We know that, and as you can imagine, since 2021, this task force has banded together to come up with these suggestions. But please, keep yourself posted, stay across all of our social media platforms, and we'll definitely, we'll definitely drop something as soon as it hits the ground running. So another question that has come up, just bear with me, is around independent contractors in the recruitment space. So we have people that might be in the recruitment space that is working, set patterns and consistent hours. Look, I think it's really important right now with as I mentioned in that slide about independent contractors, right now with the way that we're moving and the way that we're headed, we can see that the Uber case was a benchmark case for us. From there, we're going to have a look at these tripartite arrangements, these recruitment arrangements, and it hasn't been tested yet. But what we can say is for these particular situations, you need to make sure that there is a clear line of separation, that you have an an independent contractor that is coming in, doing their hours, they're bringing their own equipment. All of those factors are what's going to tie into it. It's not necessarily the continuous work pattern that will set it off as being an employee, but there are variable factors and lots of things to consider that will make it lean more towards one over the other. And I think that's probably the better way to look at it. But definitely it's worthwhile to, if you are dealing with this, to look at the agents that you have, the consultants, and go, okay, how many people are engaged in this basis? How much of them are actually involved in the business? What are we doing? And how can we separate that and maybe start creating some degrees of separation there? Yes, so there is a statute of limitations. Somebody has asked around wage claims being 6 years. So wage claims under the wage protection legislation, all of that is a little bit separate to your minimum entitlements and your holiday pay. But even then, like I said, with those situations, you're not normally dealing with an independent contractor that has left 20 years ago and they're coming back. In these situations, you're normally dealing with a case where this person's potentially working with you or for you, and they're an independent contractor and they're leaning more towards an employee. And that's where you would have to have a look at the Holidays Act, the legislation, and see how far back you need to go for that to rectify the issue. But like I said, it's your business decision. It's an employer's decision on when they want to do what they want to do and when they want to do that. And I think it's really important for them to seek advice around that as well. All right, I'll just have a look at questions around, so HR advisors, somebody's asked around if they need to be paid $29. Like I said, it's what comes under that particular visa. So it's the visa class, the conditions on the visa. So I would highly recommend, if you have any questions around a rate of pay for what particular employees, really do reach out to Immigration New Zealand. They will give you the right steer. And if anything is really complicated, then having a licensed immigration advisor will be very, very useful as well. And so I know that I mentioned the 4-part test, and I'll take a little bit of time out to discuss that. So the 4 parts are around, like I said, one is intention. So what is the intention of, and the 4-part test is associated with contractors and employees. The first part is around intention. So when you're actually engaging this independent contractor, what is your intention? A lot of times the intention is in writing. It may seem like it's a contract between a particular company and this contractor, but then you have to kind of peel it back and look further, and that's when you look at how much control is over this particular independent contractor. And that's the second part of the test. The control is around how are you monitoring them coming in and out? Are you giving them their equipment to use? Are you telling them that they need to start at this time, finish at this time? Are you monitoring them as somebody watching the work that they're doing? Because it can't be performance-based. It's about the level of service that they're providing. Just like if you had a broken window and a contractor came in to fix it, like I said before, I hope no one's sitting there just watching the contractor work away, but it would be about looking at them coming in, doing their job and leaving, and you're not really there controlling and manning the work that they're undertaking. The third part of the test is the integration angle. So generally, if you're an employer, you will know that you need to be fully integrated into the business. That's usually how it will work, and an employee will come to staff functions or be part of that workplace culture. And again, with independent contractors, they shouldn't be integrated that way. They need to have this degree of separation, and it is best practice to have them not fully involved in the day-to-day. And then you also have the fourth part of that test, which is around economic reality. So who actually is benefiting from this work? Is the employee benefiting, the independent contractor benefiting because they're getting money for the service that they're providing, and that's it, done and dusted? Or is it actually this company, the employer, is benefiting by not having to pay holiday pay, doing all of that, and they're not having to worry about that while still getting the benefits of having this independent contractor or employee. So I'll just get to one last question that we've got, which is around the minimum wage. So when the minimum wage change takes effect, are employees paid above minimum wage also entitled to any pay adjustments? No. So they are not, they're not going to have to be bumped up or anything like that. It's just about making sure that that you are paying everybody the minimum wage. I do remember from my time in advisory that absolutely when the time came, employees would push and see if they could get a bump up in their wages because other people were getting a raise as well, and that was because the minimum wage was changing, not necessarily that they were being rewarded for exceptional work or based off of a performance review. So I would say what's something to consider as an employer is how you're going to navigate that space, making sure that the wages and all of those discussions are confidential. If they do come out, then you can have a look at reassessing and seeing if you can bump up even slight increases for other people. But it's just a matter of seeing as an employer how you want to navigate that. But no, there is no legal requirement for you to increase if they are being paid the minimum wage. But also just double check your policies and any documents that you might have, just in case if you've got anything in place that says, we will do an annual performance review or something, and we will increase on a yearly basis or whatever it might be. Another question that has come up is around, would you remove an independent contractor from a company email distribution list? Would that be deemed as being an employee? Like I said, again, it's about the weight of it. So you have to look at how many things are leaning towards an independent contractor and how many things are leaning more towards an employee. Generally, you wouldn't include an independent contractor in a mailing list when they are going to employees, but in some circumstances it might be necessary. But again, it brings me back to that Uber case where it doesn't matter the reasons that these Uber had. At the end of the day, the reasons were not irrelevant. It was all about whether or not the particular independent contractor should have been engaged in that particular way, and how much control was over them. So I've got another question here as well around independent contractors. I love that this is a very buzzing topic. It's very good. I thought it was nobody would be interested in this, but I am very glad. We have one about around this being similar to the UK, where you shouldn't hold onto an independent contractor after 12 months. if they receive the same rights as a permanent employee. Here, it's a little bit different. What you're looking at is when a situation arises where you feel like they are more of an employee than an independent contractor, then general practice, best practice, you know, and that would be advised is to act in good faith as an employer would to an employee, and offer them employment. But then, like I said, each situation is different, and you really need to think about whether you want to go down that path of even doing that and engaging them. And if you don't do that, what are the consequences and the risks of not engaging them as an employee? One of the last questions that we have here is around, what if an independent contractor is happy on this arrangement and does not want to be classed as an employee? Look, it is all about the balance, about how much risk as an employer you want to take. Yes, absolutely. I'm sure many of you out there would have had an employee that was all happy, hunky-dory, up until one day when things just completely went kaput and the employee was unhappy. And now everything that you may have done in the past to help the employee is now you know, cast a light upon, and the employee is making it seem like it was a negative thing. So I think that that's where you would have a look at this scenario and go, okay, even though the independent contractor wants this, I need to act in the best interest of me and my business, and what would be the best thing to do. And that's where I would say, get some legal advice, see you know, if you want to go down that path and what the risks will be if you don't. All right, well, I think that that just about sums up the questions. If anybody's got anything else, feel free to pop it in. We still have a couple of minutes, but I can't see anything coming through. So like I said, you know, we're definitely here to help. And if you have any questions or anything that that comes up, you know, where you're dealing with a specific circumstance, please reach out to somebody in your you know, in your area, an expert, a lawyer, an advocate. But in terms of how we can help, we're absolutely there to help with you know, this platform, this beautiful, amazing piece of technology that will actually allow you to monitor and keep up to date with your employees and legislative changes. So you know, with that, I just want to conclude by saying thank you so much, everyone, for tuning in. I hope it was informative, and I know that some of the changes haven't officially come in yet, but it's always good to see what's happening in the foreseeable future. But thank you so much, everyone, for joining us today. And you know, a survey will also pop up after I you know, end the session, and we would really appreciate if you could just complete the survey, just to give us some feedback as well. I would love to know if there's anything that you would like tweaked or any changes. And we will also be sending out additional resources. I know, like I said, we got some questions around you know, particular areas, so I'll work on getting some stuff out about that, as well as the slides will be provided as well. And please keep in mind, this was recorded. So thank you, everyone. I hope you have a lovely afternoon, and if you know, if you have any other questions or anything that come up, please feel free to contact us. But thank you so much, and have a great day.